Well, friends, Special Counsel Jack Smith adjusts to the Supreme Court presidential immunity ruling. He goes back into the grand jury and he re-indicts Donald Trump for his democracy-busting crimes. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, who saw this one coming? I didn't. I did not have a Donald Trump superseding indictment on my bingo card. But let's talk about what was a smart, important, and strategically shrewd decision by Jack Smith. But before we turn to the new reporting, if you'll indulge me just 30 seconds, as you may know, here at Justice Matters, we are an all-volunteer operation. We're up and running 7 days a week, posting a legal analysis video every day, and we couldn't do it without your support. So if you're interested in more formally supporting our all-volunteer efforts, our mission, our content, please feel free to come on over to patreon.com. You can sign up to become a patron, and if you do, I will send you some Team Justice and Justice Matters stickers and a personal handwritten note of thanks. Now, let's turn to this blockbuster. That word is actually appropriate today. Blockbuster, new legal development, a superseding indictment of Donald Trump, and I don't want to bury the lead. This new indictment, after Jack Smith adjusted for the Supreme Court's horrific presidential immunity ruling, after he adjusted and pulled out all of the stuff that might run afoul of the Supreme Court ruling, guess what? All 4 felony crimes remain. Donald Trump will go to trial, in Jack Smith's estimation, for all 4 felony crimes that appeared in the first indictment, because all 4 appear in the superseding or subsequent indictment. I'm a little excited about this legal development, but let's start with the new reporting. This from Reuters. Headline: Donald Trump faces revised U.S. indictment in election subversion case. And that article begins, Donald Trump faced a revised federal indictment on Tuesday accusing him of illegally trying to overturn his 2020 election loss, with prosecutors narrowing their approach after a U.S. Supreme Court ruling that former presidents have broad immunity from criminal prosecution. U.S. Special Counsel Jack Smith's team obtained the superseding indictment in the Washington case, though it was highly unlikely to proceed to trial ahead of the November 5 election, when the Republican Trump faces Democratic Vice President Kamala Harris. The revised indictment lays out the same 4 charges prosecutors brought against the former president last year, but this one focuses on Trump's role as a political candidate seeking re-election rather than as the president at the time. The Supreme Court ruled on July 1st that Trump is at least presumptively immune from criminal prosecution for actions that were within his constitutional powers as president. U.S. District Judge Tanya Chukka in Washington has been expected to decide in coming weeks which aspects of the case must be tossed out based on the Supreme Court's immunity decision. Okay, friends, let's talk about why this was a really smart, strategic, and tactical decision by Jack Smith, getting this new indictment. So the first indictment that the first grand jury returned against Donald Trump, as you well know, contained 4 crimes, 4 democracy-busting crimes that Donald Trump committed while president. And then the Supreme Court got its hands on the case and on that indictment and said, well, wait a minute. presidents should have a healthy dose of absolute immunity for the crimes they commit against the American people designed to try to steal a presidential election if the things he did were official presidential acts or core constitutional functions. How crimes to steal a presidential election could ever be interpreted as official presidential acts or core constitutional functions of a president is beyond me. That's why this is a horrific Supreme Court opinion that we have to live with until it is reversed, and it goes the way of other horrific Supreme Court opinions over time. But the Supreme Court got their hands on the indictment and said, well, somebody's got to figure out which of these crimes by Donald Trump, which of these acts by Donald Trump are official presidential acts, so they should enjoy some immunity, and which are unofficial presidential acts, which are the acts of a candidate seeking the presidency. And y'all just sort that out. And they kicked it back to the trial court. So not surprisingly, when you go through the 45-page indictment, there are lots and lots of acts undertaken by Donald Trump, criminal acts, many of them, and we had to figure out which ones were official presidential acts and which ones weren't. So we would know which ones Donald Trump might have immunity for and which ones he doesn't have immunity for. So what we all thought was the next thing that would happen there would be this hearing that is coming up, and it will be presided over by Judge Tanya Chukka. She is the one presiding over Donald Trump's January 6th trial, his election interference, election subversion trial in D.C. And we thought that evidence would be presented and Judge Chutkan would have to rule after the parties litigated the issue and made their best arguments which acts, which conduct of Donald Trump in that 45-page indictment survived the Supreme Court ruling on presidential immunity, which acts, which crimes were not official presidential conduct. And we thought that this hearing would be held and we would get a ruling on each and every act. Nope. Jack Smith said, I'm not going to sit back and wait and be reactive. I'm going to seize the initiative. I'm going to be proactive. And he went back into a brand new grand jury. Please put a pin in brand new grand jury because that's going to be really important to where Jack Smith ended up. I'm going to go back into a new grand jury. And I am going to present evidence to the new grand jury only of acts that Donald Trump did that we do not believe were official presidential acts. They were the act of a candidate, or they were not otherwise official presidential acts. I'm only going to present evidence of acts that should not enjoy presidential immunity under the Supreme Court's new ruling. And he did that. He presented that evidence. He extracted a good bit of the evidence that was presented to the first grand jury, and he asked them to vote on charges. And here is the great news for accountability, friends. There was enough evidence in the estimation of Jack Smith and his team to support all 4 felony crimes that were indicted in the first go-round, even pulling out the stuff that might enjoy presidential immunity. All 4 felony crimes remain in the superseding or second subsequent indictment, which replaces the first indictment. And the new indictment is 36 pages, not 45 pages. So he pared it down, 9 pages, took a lot of stuff out, right? Condensed some of it. And here is why it was so important that he presented it to a new grand jury. And this is going to feel a little bit like a Team Justice Law School class, but I'm going to try to keep it concise. When we investigate cases in the grand jury, I was a federal prosecutor my whole professional career, investigated more cases before grand juries than I can ever count. There is some evidence you can put before a grand jury and some evidence you can't. For example, you might not know. Obviously, you can put relevant evidence before a grand jury when you're trying to give them enough evidence to decide if somebody should be indicted, but you can also present to them irrelevant evidence if that irrelevant evidence is reasonably likely to lead to relevant evidence, because the grand jury investigation is just that. It's an investigation. It's wide open. There are no rules of evidence that apply, right? It's not a trial. It is a broad, far-reaching investigation. So you can present irrelevant evidence. Believe it or not, you can even present evidence that may have been taken by the police in violation of the defendant or the target of the grand jury investigation, the target's constitutional rights. So if evidence was seized, maybe in violation of somebody's protection against an unreasonable search and seizure, as embodied in the Fourth Amendment, or against somebody's right against self-incrimination as embodied in the Fifth Amendment to the Constitution, you can present that to the grand jury. Why? Because it's not a trial. And there's no mechanism to test whether that evidence should be suppressed, should be thrown out or not. That comes later in the process, after the indictment, when you're litigating the evidence that can or cannot be introduced at a trial. So you can present evidence that might have been taken in violation of a defendant's constitutional rights. You can present it to the grand jury. This may seem counterintuitive, but this is what I teach my GW criminal justice students every semester. But there are also some things that you cannot present to the grand jury, and if you do, you might taint the indictment, and the indictment itself might be thrown out. Evidence like attorney-client privileged information. I can't put a witness in the grand jury and ask that witness, well, you talked to your lawyer about your testimony here today, didn't you? What did your lawyer tell you? And what did you tell your lawyer? That would violate a legal privilege that the witness has. That could taint the entire grand jury investigation and the ultimate indictment, and the whole thing could get thrown out, right? The same holds true for other privileges, spousal privilege, doctor-patient privilege, and executive privilege, or the privilege that the Supreme Court just conjured up out of whole cloth, made up, contrary to the Constitution. Yeah, I'm stuck on that. And it is the presidential immunity privilege, right? So think about it. If Jack Smith just went into court with the original indictment, where the grand jurors had heard all of this evidence about, for example, Donald Trump communicating with his DOJ officials, that would have been privileged information that the grand jury was sort of not legally eligible to hear, and that could have resulted in the whole indictment ultimately being thrown out. Jack Smith said, I'm going to cut that off at the pass. I'm not going to give Donald Trump's lawyers the opportunity to make that argument in court, so I'm going back before a brand new grand jury who has heard none of the evidence and only present the evidence that is not privileged. Stroke of genius. Really smart, strategic, and tactical decision by Jack Smith. And that is how we have come to this new 4-count, 4 felony crimes against Donald Trump, 36-page superseding indictment, on which Donald Trump will be arraigned. We've heard some reporting that the prosecutors won't insist on Donald Trump being personally present for his arraignment, even though defendants normally need to be personally present. I mean, Donald Trump has been arraigned how many times at this point? You know, we can let one personal appearance slide at this arraignment. And I actually think there are good reasons to waive his appearance, because otherwise, you know, blocks and blocks around the federal courthouse downtown here have to be shut down, and you bring all kinds of law enforcement agencies in, and you know, it's a 5-minute hearing, and it really is quite disruptive to everybody's lives in and around the federal courthouse, and there's no need for that. You know, Donald, you stay down in your little club down in Florida. You don't need to come on up here and be arraigned again. I mean, in what jurisdiction haven't you been arraigned? New York and Georgia and Washington and Florida, and there are probably more arraignments coming. Remember, Donald is an unindicted co-conspirator at the moment out in Arizona. Frequent flyer on the criminal justice front. So now we are waiting to see what Judge Chutkan will do. There is a schedule in place. We'll see if she alters that schedule, and if she doesn't, we'll be in court. I'll be monitoring what goes on in court in downtown DC and bringing it to you in Justice Matters videos as soon as things unfold in court. We'll wait to see if she modifies the schedule, and if not, we'll be in court, I believe, on September 5th. And Judge Chutkan will take up the issue of, okay, we've got this new indictment, Donald Trump's been arraigned on it, let's go ahead and sort through it. Because prosecutors, Jack Smith, have taken out lots of the stuff that might have run afoul of the Supreme Court presidential immunity case. So I think Jack Smith has actually made Judge Chutkan's job much easier. And the fact that 4 felony charges remain, even after the privileged stuff was pulled out of the indictment, is a really good sign for the prospect of accountability for Donald Trump's crimes. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.